Dear students, welcome to my YouTube channel Your Short Questions with Narayan. In today's video, we will be discussing about around 40 the most important very short answer type questions and their answers which are important for judiciary exams, semester exams, Union Public Service Commission exams, State PCS, UGC Net Law and other competitive exams related to IPR law. It is of intellectual property right. So let's start from question number 1. Which industries are most involved in biopiracy? The pharmaceutical, biotechnology and agriculture industries are the most involved in biopiracy. Name few international conventions or treaties related to IPR. First is Paris Convention for the Protection of Industrial Property 1883, Bern Convention for the Protection of Literary and Artistic Works 1886, TRIPS Agreement, that is Trade Related Aspects of Intellectual Property Rights 1995, WIPO Patent Cooperation Treaty PCT of 1970. What is an example of biopiracy? The patenting of neem and turmeric by foreign companies without acknowledging their traditional uses is an example of biopiracy. What is intellectual property? Intellectual property refers to the legal rights granted to individuals or entities over the creations of the mind. These rights allow creators to protect and control the use of their intellectual efforts, ensuring they can benefit from their work and prevent unauthorized use. Intellectual properties are inventions, literary and artistic works, symbols, names and designs, industrial designs, and geographical indications. Why is biopiracy a concern? Biopiracy exploits the biodiversity of developing countries and denies rightful benefits to the indigenous communities. Intellectual properties can be of various forms. What are these? These are patents, copyright, trademarks, industrial designs, geographical indications, trade secrets, plant variety protection, layout designs of integrated circuits. What can prevent biopiracy? Implementing strong intellectual property right laws and adhering to international agreements like the Convention on Biological Diversity can prevent biopiracy. What do you mean by copyright? Copyright is a legal right granted to the creator of an original work which provides them with exclusive control over its use and distribution for a specific period. It is designed to protect the expression of ideas, not the ideas themselves, and applies to works in various forms such as literary, artistic, musical, and digital content. What are the challenges in protecting traditional knowledge? Challenges include lack of legal frameworks, biopiracy, and inadequate documentation or recognition to the traditional knowledge. What is the term of copyright in India? For literary, dramatic, musical and artistic works, lifetime of the author plus 60 years after his or her death. Cinematograph films, sound recordings, it is 60 years from the year of publication or release. Broadcast reproduction, 25 years from the year of the broadcast. Performer rights, 50 years from the year of the performance. How can traditional knowledge be protected? Traditional knowledge can be protected through legal measures, intellectual property rights, and community empowerment initiatives. What are the criteria for copyright infringement? Ownership of a valid copyright, unauthorized use, substantial similarity, access to the original work, violation of exclusive rights. Why is traditional knowledge important? It plays a vital role in preserving cultural heritage, supporting sustainable practices, and offering solutions in fields like medicine and agriculture. What are the authorities under the Copyright Act of 1957? They are the Registrar of Copyrights, also known as Copyright Office, the Copyright Board, and the Copyright Societies. How is traditional knowledge linked to biodiversity? Traditional knowledge often includes insights into sustainable use and conservation of biodiversity based on long-term observation and experience. What is the Statute of Anne? The Statute of Anne is a landmark piece of legislation in the history of copyright law. It was enacted in England on April 10th of 1710. It is considered the world's first piece of copyright law. Can a copyright holder license their rights to others? Yes, a copyright holder can grant license to others to use their work under specific terms and conditions. What is the duration of copyright for a joint work? 60 years after the death of the last surviving author. What are the rights of a copyright holder? A copyright holder has the exclusive rights to reproduce, distribute, publicly perform, display and create derivative works from their original creation. What is collective mark? Give examples. Section 21Z of the Trademark Act, collective mark is a mark that indicates the association of multiple entities with the trademark owner, typically used by members of a collective organization. For example, in India, CA mark is a collective mark used by members of the Institute of Chartered Accountants of India, ICAI. Only qualified and registered members of ICAI can use this mark. Do copyright holders have moral rights? Yes, copyright holders have moral rights such as the right to attribution and the right to protect the integrity of their work. What is certification trademark? Give examples. Section 2, subsection 1, subsection E deals with certification trademark. It is a mark that certifies the goods or services in respect of origin, material, quality or other characteristics. Examples, ISI mark in India issued by the Bureau of Indian Standards. The ISI mark certifies that a product meets the quality and safety standards set by BIS. How long do the rights of a copyright holder last? In most cases, copyright lasts for the creator's lifetime plus 50 to 70 years, but it depends on country to country, jurisdiction to jurisdiction. What is a well-known trademark? It is dealt by section 21ZG. It is a mark that is widely recognized by the public as associated with a particular good or service, making it eligible for broader protection even for unregistered categories. Can a copyright holder take legal action for infringement? Yes, a copyright holder can file a lawsuit against anyone who uses their work without permission, violating their rights. What is classification mark? Classification mark refers to a label or symbol used to categorize a product, service or entity based on certain characteristics or standards. In business and marketing, it is commonly used to identify the quality, features or regulatory compliance of a product or service. Example, ISO certification mark. What are the criteria for an invention to be patented? An invention must be novel, non-obvious and useful to qualify for a patent. What are the remedies for passing off? Injunction, damages, accounts of profit, delivery up and order for destruction are the remedies for passing up. How long does a patent last? A patent typically lasts 20 years from the date of filing, subject to renewal or jurisdiction. What are the types of passing off? There are three: direct passing off, indirect passing off and reverse passing off. What is the significance of a patent? A patent protects the inventor's rights, encourages innovation and prevents unauthorized use of the invention. What do you mean by patent? A patent is a legal right granted to an inventor, giving them exclusive rights to use, produce or sell their invention for a specific period. What are the criteria for an invention to be patented? An invention must be novel, non-obvious and useful to qualify for a patent. I think this question is repeated. Never mind, it's a revision. What are non-patentable inventions in India? Inventions contrary to natural laws, inventions harmful to public order or morality, discovery of scientific principles or abstract theories, mathematical methods, plants, animals and biological processes, traditional knowledge, methods of agriculture or horticulture, medical, surgical or diagnostic methods, atomic energy related inventions are non-patentable in India. What is the significance of a patent? A patent protects the inventor's rights, encourages innovation and prevents unauthorized use of the invention. What are non-patentable inventions in India? They are dealt by section 3 and 4 of the Act and excluded from patentability, such as inventions contrary to public morality or health, mere discovery of a scientific principle, algorithms, business methods and mathematical methods, atomic energy related inventions. Once again a repetition, never mind, it is a revision. What are the types of trademarks? Product marks, service marks, collective marks, certification marks are the types of trademarks. Mention the patentable inventions in India. Patentable inventions in India are novelty. The invention must be new and not part of any prior existence. Inventive step. The invention must involve a technical advancement or have an economic significance that is not obvious. Industrial applicability. The invention must be capable of being manufactured or used in industry. Subject matter. The invention should fall within the categories of patentable subject matter as defined in the Patents Act. What is the significance of patents in IPR? Patents grant exclusive rights to an inventor to make, use, sell or distribute their invention for a specific period. This encourages innovation by rewarding inventors and fostering technological advancements. TRIPS allows countries more time to fully comply with the agreement. What term is given to this time allowed? This is known as transitional period. Name any 4 types of intellectual property: patents, trademarks, copyrights, industrial designs. What is a design as per Designs Act of 2000? According to section 2D of this Designs Act 2000, a design is the features of shape, configuration, pattern, ornament or composition of lines or colors applied to any article. The article could be 2-dimensional, 3-dimensional or both, which are judged solely by the eye. What are the main objects of intellectual property rights? The main objects are to encourage innovation and creativity, to provide exclusive rights to creators or inventors, to promote economic growth by protecting and commercializing intellectual assets, and to ensure recognition and financial benefit for the creators. What are exclusions from designs protection? Designs not new or original, designs contrary to public order or morality, functional or technical features, designs not visible during normal use, designs already registered or protected, methods or principles of construction. What is meant by patent infringement? Patent infringement refers to the unauthorized use, production or sale of a patented invention without the permission of the patent holder. What is Locarno classification? The Locarno classification is an international system used to classify industrial designs based on their functional and aesthetic features. It is maintained by the World Intellectual Property Organization (WIPO) and helps in the registration and search of industrial designs worldwide. What is the duration of a patent in India? The duration of a patent in India is 20 years from the date of filing the patent application. Name any 5 Indian products having been accorded GI tag. They are Darjeeling tea West Bengal, Mysore silk Karnataka, Fulmani haldi Odisha, Banarasi sari Uttar Pradesh, Alfonso mango Maharashtra. Name any 2 types of invention that cannot be patented. Inventions contrary to public order or morality, discoveries of scientific principles or abstract theories. Define traditional knowledge. TK refers to the knowledge, skills, practices and innovations that are developed, preserved and passed down through generations within a community. This knowledge is often closely tied to the culture, heritage and environment of the community and is typically used for agriculture, medicine, conservation and cultural expressions. Who grants patents in India? The Indian Patent Office, also known as the Controller General of Patents, Designs and Trademarks under the Ministry of Commerce and Industry, grants patents in India. What do you mean by biopiracy? It is the unethical or unauthorized exploitation of biological resources such as plants, animals or traditional knowledge by individuals, corporations or organizations. It often involves the use of indigenous knowledge and resources without proper acknowledgement, compensation or benefit sharing with the local communities or countries that are the original custodian of these resources. What is a patent? Patent is an exclusive legal right granted to an inventor to make, use, sell or distribute their invention for a certain period, protecting it from unauthorized use. I hope you like this content of this video, which are useful for your UPSC competitive exams and semester exams. Please do subscribe and hit the bell icon. Please like it and share it. Your comment is vital. Do comment always. Thank you so much for watching me. Thank you.